Greetings, brothers and sisters, fallen angels, those lost within the English Empire, who I call the long lost English people. It is your brother Dion de Belmont from the illustrious noble house of Belmont, and today is February 4th, 2976 of the Berber calendar, which is equivalent to your 2026 Gregorian calendar. And I like to say always, all time, it is a beautiful time to be alive. I have to give honors to our Creator, to the Divine Father, as well as our Divine Earthly Mother. I had to give honors to our ancestors, those who are come and gone, our kings, queens who have come and gone, saints, martyrs, as well as the righteous amongst the world. I had to give honors to our king who's living today, as well as to our queen. Also have to give honors to the brothers and sisters who's been holding the fort down, and for those of you who need to hear this information the most. So once again, thank you. And for those who just now have an opportunity to hear my voice, please don't forget to like, share, subscribe if this information resonates with you. And if not with you and you feel it's going to resonate with someone else, please share to them, because we are living at a very critical time in life right now. And it's very imperative that those who recognize themselves as English people to recognize my voice and understand what is being relayed today. And this video today specifically, we're going to be talking about English child custody law. And why this is an important topic is because lately, for those of you who've been paying attention to the channel, I've been posting up, scriptures, and especially in regards to the father. Here in the West, we know there's a very big disbalance when it comes down to child custody rights, as well when it comes down to a father having their parental rights, being enforced. And we know this comes from some source. There has to be a root to this issue. And the only way for us to solve this conundrum is we have to travel back in time. Have to look at some archives and some documents that many of you choose not to do because of either you don't have the time or it's not something that you care to recognize. But due to the plight and the situations that's going right now in the West, especially within the so-called nuclear family that doesn't exist anymore, especially once again, since a lot of fathers are not actually in the household where their children are at. I can be one to actually speak in regards to that sentiment. My children, I would love for them to be in my household, but due to the situation in regards to what I'm going to be talking about today, is the reason why that cannot be the case. And I also feel that the Creator puts us, especially the messengers, in these simulations or scenarios with everyone else. So therefore, as we're, as problem solvers, we can help solve this issue, and hopefully we can do it together in regards to the remedy. But this is only going to be for those whose heart is in the right place. This is not meant for those of you who are trying to, have malicious intent or ill intent or anything in regards to how this information is going to apply to you. But for those of you who are going to pay attention to this, as time moves on, the status and the empire of the Father will return. I promise you. That's what everything is pretty much leading up to. As the world that we see, especially here in the West, is losing stability, is losing structure, and we know that structure all comes through what? The Father, and the Father getting his order from who? The Great Father. But before we go down that corridor, let's go ahead and focus on this publication that's coming from Wayne State University, and we see it's noted the English Child Custody Law, 1660 to 1839, the origins of judicial intervention in parental custody. So this is not something that they haven't been dealing with for quite some time. And that's what I'm saying. Only way for us to fight these judicial issues, especially as fathers, you have to know where all of these problems are stemming from. So let's go ahead and get started. Don't forget to like, share, subscribe, brothers and sisters. This is the only way for me to pretty much get the information out there. Donations, please, if you can, because that's the only way, once again, I can help keep this channel going, because I still have to live a regular life like many of you do. But this channel, to keep it going, for me to be able to, do this research for you, I'm going to need some assistance, All right, so let's go ahead and get started. So it said the abstract, and this has been written by Sarah Abramowicz, from Wayne State University. And it says, many legal historians see pre-1839 English child custody law as consisting of near absolute paternal rights. These historians believe that the weakening of fathers' rights began with the 1839 Custody of Infants Act, which created certain maternal custody rights. Other historians have noted that paternal custody was qualified even before 1839 by the Court of Chancery's application of the doctrine of parens patriae. All right, so for those of you who don't know what parens patriae means, it means the parent or the father or the head of the household. Parens patriae. So it's the father of the household. All right. This note tells a different story and argues that the origin of incursions into the so-called empire of the father was the 1660 10 Years Abolition Act, a statute that ironically seemed designed to strengthen fathers' rights. The 10 Years Abolition Act granted fathers the right to appoint guardians to their children by will. All right, so pause. So it says, based off of the 10 Years Abolition Act is the reason why fathers are in the situation that we're in today, because of it was designed to strengthen our rights, but based off of that, we end up weakening our rights in general. So let's go ahead and talk a little bit about the 10 Years Abolition Act. Let me see if I'm going to pull it up here momentarily. Okay, and so like they say, the 10 Years Abolition Act of 1660 was a landmark English Parliament Act that ended the feudal system of landholding, replacing obligations like military service, which is knight service, and warship with monetary payments, modernizing land tenure and boosting economic efficiency, especially after the English Civil War. As part of the Restoration Settlement, a related 10 Years Abolition Act of 1746 addressed feudal tenures in Scotland, blah, blah, blah. All right, so that's not as important as we need. Okay, so the key aspect of it was it abolished the feudal duties, which ended the archaic services owed to the crown, such as wardship, custody of minor heirs, and purveyance, forced purchases of good. It transformed landholding, once again, to common socage, a form of freehold landholding, which fixed monetary payments. All right, so there wasn't no fluctuation of how much you're going to be paying the Lord. You're going to be paying what they told you to pay, and that was that. All right, but that's a little bit about what the 10 Years Abolition Act is. All right, so let's go ahead and continue. So, and it says that this gave us the right to appoint guardians to their children by will. Well, the ones who will be dealing with that situation would be who? The court. All right, so this is all based off of through the court. According to Blackstone, the effect of the act was to extend the father's empire even after his death, but by involving courts in child custody, even as enforcers of fathers' rights, the 10 Years Abolition Act created a tradition of judicial intervention that would eventually undermine those rights. All right, pause. So they're saying, based off of Blackstone, is the courts now undermined the father's rights that he invested into the courts via having the courts appoint a guardian for children through their will once the father was no longer there to keep the father's empire going. So in this case, for the father to have a perpetual existence, or the line can stay around for as long as possible. The father created an estate, ties children into the estate, and then through the court had chose the court to choose a guardian to help maintain the continuity of that state for the children as well their posterity moving forward. Unfortunately, the children or the heirs don't know this, and so you have foreign trustees who have been occupying or operating in capacity that's outside of their office duties. And in the fact that they're not letting the heirs know that they're the true heirs, the heirs themselves have no idea that there's actually was a trust that was created for them. And in this case, it was created by the father through a will, and it was made through the court for the court to appoint a guardian, aka a trustee, to maintain the rights that the father was setting in place for his estate, for his heirs in perpetuity. Hopefully that makes sense. All right. So it says this note traces the development from 1660 to 1839, whereby court supervision of testamentary guardians led to court supervision of fathers themselves. All right, so let me reread that. This note traces the development from 1660 to 1839, whereby court supervision of testamentary guardians led to court supervision of fathers themselves. So they completely undermined the father's rights, and now the court or the judge themselves are creating some form of guardianship that requires the father to actually have to have supervision uh, in regards to when it comes down to him and his own heirs. And like I said, and transforming the empire of the father into the empire of the judge. So now, as we can see, the judges, they're the reasons why we're into this situation, especially as fathers, is they're the ones who are undermining the rights of the father, and it's being traced going all the way back to 1660, 10 Years Abolition Act. Well, now this is important to know because the fathers who are being affected here in America, many of you don't know that you have your true nationality tied underneath those people who was underneath that 1660 10-year abolition act. And who would those people be? The English people. The English people. So as you see, the Englishman, the father who we're speaking about, which many of us are, who I am, are going through these issues, not being able to take care and have the proper custody and rights of our children, and our paternal rights being enforced because of the judges, because of, they feel that we gave them the right to do what they're doing to us. But we're going to find out why and how is that the case. And the only way for you to know that is by understanding parens, patriae, and understand partus sequitur trem. All right, so let's go ahead and get a little further into this. Okay, so now we're inside the article. And it says, once again, English Child Custody Law 1616 to 1839, the origins of judicial intervention in paternal custody. So we're going to read the introduction because we already read the abstract. The legal power of a father for a mother as such is entitled to no power, but only to reverence and respect. The power of a father, I say, over the persons of his children ceases at the age of 21. For they are then enfranchised by arriving at years of discretion, or that point which the law has established, as some must necessarily be established, when the empire of the father or other guardian gives place to the empire of reason. Yet, till that age arrives, this empire of the father continues, even after his death, for he may by his will appoint a guardian to his children. In his authoritative pronouncement on English law, William Blackstone describes custody of children under the age of 21 as the empire of the father. Blackstone advances as evidence of this empire that a father could appoint a guardian to his children by his will, thereby continuing his power even after his death. But as Blackstone was formulating his version of the father's empire, the doctrine he produces as evidence of his absolute nature, and go ahead and zoom this in a little bit better. So that way the audience can be able to read along. Excuse me. All right, as evidence of its absolute nature, was developing into authority for judges to intervene in paternal custody even during the father's lifetime. The father's right to appoint a guardian to his children by will originated with a 1660 statute. From 1660 to the time of Blackstone, the English Court of Chancery had built a tradition of supervising these father-appointed guardians, known as testamentary guardians. Beginning in the mid-18th century period when Blackstone wrote, culminating in the decades after his death, the Court of Chancery employed an analogy between testamentary guardians and fathers to extend its jurisdiction to include the supervision of fathers themselves. All right, pause. So they're saying that the Court of Chancery has set up testamentary guardians of the father to not only be guardians of the father's estate, which is his children, to appoint them to watch the children and keep the estate protected, but also for them to so-called supervise the father himself, which this is a complete contradiction in regards to why the father set this up in the first place. But let's continue. As this note will recount, some scholars have, like Blackstone, seen paternal rights as absolute under English law until the passage of an 1839 statute that created certain maternal custody rights. Others have noted the extent to which the empire of the father was qualified even before 1839. But no scholar has observed the irony that the origin of incursions into this empire was the father's acquisition of the right to appoint testamentary guardians. Pause. So the fact that with the 1660 10 Years Abolition Act and giving the fathers the ability to choose testamentary guardians, that itself is what usurped the father's rights altogether. All right, and this is why we have to understand what happened to be able to trace ourselves back in time to be able to fix these issues, because it's not going to fix itself by us constantly keep trying to go forward with these so-called new modern statutes and legislation. No, we got to go back in time, and when you go back in time, you need to be those people who these statutes are affecting, because now today you don't claim to be these people, so therefore you don't actually have a window to get out of or a door to walk through. You got to stay in that box that they put you into, unfortunately, because you claim yourselves to be Americans. I'm not writing the script. They wrote it, and you're following along with it. If you're claiming to be an American, you have to play this game. But us as English, we predate America, so therefore we can go back home and fix this. And going back home is a mind thing. Go back in time in your mind and be who your predecessors were. You got everything you need for you to be that if you desire to. And to be that requires a hell of a commitment and responsibility. I digress. Let's continue. So as this note will recount, some scholars have, like Blackstone, once again, seen paternal rights as absolute under English law until the passage of the 1839 statute that created certain maternal custody rights. Others have noted the extent to which the empire of the father was qualified even before 1839, but no scholar has observed the irony that the origin of incursions into this empire was the father's acquisition of the right to appoint testamentary guardians. Once the father was granted a means of extending his power through legal instrument, judicial interpretation and discretion seeped into his empire. There you go, the judge is seeping into our business. And once judicial discretion entered, even though initially in the guise of strengthened paternal rights, the empire of child custody was no longer the father's, but that of the judge. So as we can see, 1660 is our point a reference in regards to the fathers losing their power in regards to their custody rights, even today in regards to the children underneath English status don't have the right to be underneath their father status if the fathers don't know who they are, and then the fathers don't come and bring these proper claims to an existence in regards to how they're trying to solidify their tradition and culture and preserve their lifestyle, as well preserve that through their children, because your children is your property. Your children are your rights, and I have rights to my children to make sure that they know everything about who they are, especially as me being their father. And as me being an Englishman, it's my obligation and duty to rear them up right according to the English way, because the American way, as we can see today, that does not work, and I choose not to. And this is unfortunately a lot of the mothers, you gotta have to recognize you have been bamboozled to follow the American commercial way. You're teaching your children based off of these corporations. So I know many people say they're under a so-called patriarchy. You're not. You haven't been under a patriarchy in almost 6, 7, 8, 9, almost 400 years. You have been under a corporatocracy, which means corporations rule your reality. They rule the world. And they've been doing this ever since so-called the creation, even before the so-called creation of the United States of America, going all the way back to breaking away from the crown from after the fall of the last Plantagenet king, which was King Edward IV. All right, 1485. So once again, my children, especially you brothers and sisters who are English people, once you know your history, this is how you correct the record. This is how we can fix the conundrum, especially when they're dealing with our children today here in America, because it's time for them to actually be reared up right with a foundation and standards that actually the world look up to, they want, and something that our ancestors can be proud of. And it's not like we're creating anything new. All of it is still here. The only thing we're doing is going back to the book, going back to the beginning, and following along by reading the directions. All right. So it says this note offers a revised version of the history of English child custody law from 1660 to 1839. Part 1 analyzes the accounts of this history given by both modern scholars and pre-20th century activists and commentators. In simplifying the law of child custody either to the empire of the father or to an issue of the chancery's jurisdiction, these accounts miss the full story of the court of chancery's power to intervene in paternal custody. Part 2 begins to tell the story by explaining how the advent of testamentary guardianships led to considerable discretion by chancery. Finally, Part 3 explains how this power extended from the regulation of such guardianships to the regulation of fathers themselves. I hope you brothers, and especially you brothers, but brothers and sisters are listening to what is being said. Since 1660, the judges have been intervening into the empire of the father, which technically dismantled the father's rights. It's the courts. It's these courts, these judges. They've been evil and traitorous to the father, going all the way back as far as we can see. All right. And in its fall, like I said, in this document is short that the empire of the father fell, and that its fall originated not with the 1839 statute meant to weaken paternal rights, but with the 1660 statute meant to strengthen them. So 1660 is our year, brothers. 1660 is the year that we lost the rights to our children. And technically, it was even before that. We can go after the Elizabeth Key Greenstead case, which was a 1609 or something like that. I can't think of it right now. But after Sister Elizabeth Key Greenstead freed her and her son because she knew that she was an English woman. She knew that she was tied to the English church, which at that time they called the Church of England. They was still tied to the original English church, but we'll talk about that later. And she knew her history, she knew her ancestry, even though they say her mother was an African, which we know that can be anything, because African was a cover term. For melanated people. She could have still been an English woman. She could have been Scottish. She could have been Irish. She could have came from Northwest Africa. She could have been any nationality. But because of what she looked like at that time, they gave her so-called the identity of being African. All right, but let's continue. So 1, prevailing views of the history of English child custody law. This part critically assesses prior treatments of the pre-1839 history of judicial intervention in paternal custody. No modern scholar has focused exclusively on this history. That's why I was brought to focus exclusively on this history. Because I had to suffer the same consequences that the other brothers are suffering. Good brothers who are trying to rear their children up right, but unfortunately because of corporatocracy or the corporations have control over our women. They're utilizing our women against us. And we can't use our women the way that God intended for them to be on this planet. And the women don't even know who they are anymore. They don't even know what is a woman. And most circles today, if you talk about them, and then some folks out here talk about men can have baby. So as you see, we're completely backwards, and this goes against, the way of our predecessors who was here in the English Empire prior to so-called the creation of the United States of America, and prior to so-called 1660, and prior to the so-called age of discovery. All right. So as we can see that the courts them are what's causing these issues that we're dealing with, all right, especially as fathers. Excuse me. So it says, no modern scholar has focused exclusively on this history, and those who have discussed the subject in tangents to other explorations have made critical omissions. Without yet revealing the full story, this part explains what those omissions are and shows how similar gaps existed in pre-20th century advocacy and scholarship. And like I told you, I'm an advocate for the heirs of the Kingdom of England, Great Britain. All right? And especially I'm an advocate for the return of the father, because the mother is here. The divine earthly mother is here. The problem is she's suffering because the father hasn't returned to help bring order and structure. And this is what the West is afraid of. It's the truth coming out to bring divine order back. And like I told you before, especially those who've been paying attention to my astronomy teaching, or excuse me, my astrology talks, this is all astrologically aligned according to prophecy. They said that this was going to happen because they knew it, because history repeats itself. All right, so let's go ahead and continue. So it says the history of English child law is only beginning to receive adequate treatment by legal scholars. The child custody legislation of 1839 has recently begun to attract interest, especially among feminists. The history of English. Now, why is feminists interested in this? I'm curious. The history of the English child custody law prior to 1839 has yet to receive similar attention. To the extent that scholars have approached this history, they have done so from two very different but equally limited perspectives. The first mode of discussing the pre-1839 history of English child custody law, the more prevalent one in recent years, have been to recount this history in order to provide background for a history of American family law. All right, so they're utilizing, once again, because, America gets its foundation from England. So without England, there is no America. So for those of you who think that America exists outside of England, your understanding of America does not exist outside of England, outside of the foundation that England has set here. All right. So it says the second mode, popular until the early 1970s, had been to trace the history of parens patriae, the ancient English doctrine that the king, as father of the nation, remember the king of England. I'm not talking about the de facto British monarch over there who's a puppet head, but I'm talking about the true de jure king of England is the father of the nation. And he has the power to act in protection of the nation's weak and powerless, namely infants, idiots, and lunatics. So pause for a second. And I don't want to sound condescending or anything when I say this, and don't take it personal. But they see you brothers and sisters as idiots and lunatics. And lunatic historically was someone who's suffering from mental issues. So like we see here in the West, many of you, because you don't know this, that's considered amnesia. Amnesia is considered a mental health issue. Many of you don't know your history, therefore you're suffering from amnesia, which means you have to be what? You have to be quarantined. You need a guardian. You need somebody to take care of you. But if you don't know where you come from, then that means anybody can come in and say, hey, I'll just go ahead and take care of them because I don't know who they are, but they need to be taken care of some shape, fashion, or form. But when people come and say and do those things, you don't know if they have the right intention for you. And as we can see here, going all the way at least to 1660, that the judges or the courts didn't have the best intention for the English people, including the so-called English father. Why? Because they literally, as we just read, usurped the father's rights because he wanted to extend his empire after his death. He wanted to hear this because he wanted to extend his empire after his death. And so what the judges and them did, they usurped that right and came in and made themselves the supervisor not only of the child as a testamentary guardian, but also to supervise the father. So now the father is in the same so-called position as, which we will say here, an infant, an idiot, and a lunatic. Let's continue. So today, in both the United States and England, parens patriae is used in a variety of contexts, from protection of the mentally ill to the law of the juvenile. So once again, many of you are mentally ill. I say that with a lot of love. I really do, because I've been down many of the corridors and roads of school of thought that many of you are on. And I did deep investigative research. And a lot of you, as I see, especially since you've never done your genealogy, you're lost and you're suffering from what I call, and which they call, emotional idolatry. So that means that even with the facts being presented to you, you still won't believe it because it makes you feel uncomfortable in some type of way based off of the reality that you were trying to construct based off of what you feel and believe in your heart. You're throwing all logic out of the window, you're throwing all facts out of the window, and you're just focusing based off of what you feel and what you have summed up from your existence, that this is what it is. And unfortunately, because of you think like that and don't truly know the truth, you have to be quarantined. This is not up for discussion or for debate. That's the reason why you're being treated like this, brothers and sisters. All right, so let's continue. All right, so the mentally ill to the law of juvenile courts. In order to justify the state's power to intervene, scholars exploring the scope of this doctrine have had occasion to examine its history. Excuse me. Oh, and point of interest, the governor is considered your parens patriae for the state. All right, so whatever state you domicile in, your governor is considering your parens patriae, especially if you don't know that you're a descendant from the Kingdom of England, because if you did and you still had your allegiance to the king, then you know your parens patriae is the king. All right, but it's the fact, once again, because many of you brothers and sisters are still suffering from amnesia, you don't know that, so you're seen as chattel property for the state, as stock. But I'm not gonna go down that yet, because many of you ain't ready yet. But they see you as stock, chattel property. All right. So both groups of scholars emphasize particular aspects of English child custody law and omit other equally significant aspects, thus painting a misleading picture of the law as a whole. So you see, they were picking and choosing and omitting information. So therefore, like they said, they can paint a narrative that only they are benefiting from and we are losing. All right. The first group examines only one small subset of child custody cases, and it is the cases that define the contours of the English court's power to control paternal custody. The second group emphasizes the issue of Chancery's jurisdiction at the expense of a discussion of the development of the substantive law. This section will discuss these accounts in turn. So 1. Historians of American family law, Michael Grossberg and Mary Ann Mason, have recently published important works on the history of American family law. In the sections of their works dealing with child custody law, both Grossberg and Mason argue that under the system of English law inherited by the colonies and followed by American courts well into the 1800s, the father had an absolute right to the custody of his children. I repeat, in the sections of their work dealing with child custody law, both Grossberg and Mason argues that under the system of English law inherited by the colonies and followed by the American courts well into the 1800s, the father had absolute right to the custody of his children. Brothers and sisters, do you not understand what this is? This is letting you know that they have been maliciously, with ill intent, trying to remove the father out of the picture. Yes, they've been trying to move the father out of the picture for quite some time. But based off of the article, it started here in 1660. Now look what's going on here in the West. Most of these women are pushing the fathers out of the picture, finding reasons to not allow the fathers to be there to rear the children, coming up with so many different excuses. It's ridiculous, and the whole world sees this. But the only way for it to be fixed, it have to be done judicially, based off of your status on who you are and how this pertains to you. Because in 1660, the people who this affected was the English. So you must be English to fix these issues that's taking place here in America when it comes down to the father rights in regards to upholding the empire of the father. Now, that's why I had to come and do this lesson. Because what happens is the ancestors will put you in uncomfortable positions, especially when they know how you feel about your loved ones, especially as a man feel about his children, to come and bring out this information that has been buried through time. And like I'm telling you, angels are time travelers. So we only think based off of the time we come from. That's how the blood operates. But I don't want to get too off into that. But the thing is, it's the time for this information to come and see the light of day again, because the children are going to suffer if we don't. If the fathers do not return and the fathers have some type of foundation and leg to stand on, because right now, just by you saying, oh, I'm doing the best I can for my children, or I'm doing this and I'm doing that, that's not going to suffice, especially in the courtroom, especially if you don't know who you are. You need to have a power that supersedes those judges. And the only way for you to have a power to supersede those people, you have to exist before them. And you have to be those people. English people. Let's continue. Grossberg and Mason used this characterization of English legal history to show how 19th century American law diverged from its British counterpart. Under this analysis, the American courts acted throughout the 19th century to replace the British system of paternal rights with a judicial discretion that focused on maternal rights in the best interest of the child. So, let's go to Partus Sequitur Verentrium. Partus Sequitur Verentrium was initiated in Virginia. And I want to say the same year. Excuse me. The same year. And give me 1 second. Let me go ahead and probably pull it up. And this is nothing against the mothers. I don't want y'all to think that I'm, picking it on the mothers at all. No, trust me, I'm not. I love my mothers. I love my sisters. I love y'all. But it's time for the truth to pretty much be said. It's time for the facts to be presented, because you don't know what these people are setting you up for. And I don't even want to call them people, because real people, real humans won't be doing what they're doing to us. So there's something else, and I don't even want to give it a name, but let's just say it ain't what you and I are. All right, so Partus Sequitur Verentrium is said, which means that which is born follows the womb. So as you can see, because America during this time was still what? Practicing slavery. Yes, America was practicing slavery tough at this point still. Remember, Britain ended it in 1807. America then ended it to after the so-called, the Emancipation Proclamation of 1830 something or 50, I can't even remember the year, but it was definitely, it was 1865, excuse me. Emancipation Proclamation of 1865. So as you can see, they weren't planning on freeing you, period, especially if it took that long. All right, so Partus Sequitur Verentrium was a 17th century legal doctrine enacted in American slave colonies, starting with Virginia in 1662. So as you can see, 1660s when they said the so-called fathers lost his rights. And then in 1662 is when Partus Sequitur Verentrium was initiated into the so-called colonies. And then as we can see right here, it says, under the analysis of the American courts throughout the 19th century to replace the British system of paternal rights with a judicial discretion that focused on maternal rights and the best interest of the child. So this is all still tying or stemming from off of the Partus Sequitur Verentrium that they had passed in the colonies for them to go ahead and take over the rights of the child, or excuse me, take over the womb based off of taking the rights of the mother and putting her in perpetual bondage. And anything that came from out of her, male or female, was still considered a slave too. This characterization of British law as consisting of absolute paternal rights is an incomplete one that serves more as a foil for Grossberg's and Mason's arguments about American law than as an adequate picture of the English law of child custody. Grossberg, for example, states that the English Court of Chancery beginning in the 17th century developed a doctrine called parens patriae, which allowed it to interfere in paternal rights, but does not cite any instance of the English applications of this doctrine. He goes on to assert that the development of parens patriae into a means of challenging paternal custody rights went on more rapidly and fully in North America. You hear this? So in North America, as we can see, which was the location of the English Empire, were putting parameters in place to hurry up and usurp the right to the father, and like they said, paternal rights and paternal custody rights, excuse me. and to hurry up and try to placate is, oh, well, what's best for the child? Like they say today, oh, well, what's best for the child? What's best for the child? What's best for the child? Well, since you haven't been giving the children to their fathers, which is actually best for the child, look what's been going on here in the West. And I prove my case. All right, so Grossberg, once again, does not cite any English case to support his assertion that the challenge to paternal rights progressed more rapidly in the United States than it did in England. Nor does he cite any cases demonstrate his next claim. That is, was an American case law that a father's custody power evolved from a property right to a trust tied to his responsibility as a guardian. Pause. So they're telling you that the father, his custody power was evolved from a property right. Why? Your children is your property. What comes from out of me is my property. So that means that if you copulate with a woman, remember the semen comes from the man. You copulate with the woman and she becomes pregnant. That doesn't mean that that's no longer yours. No, that's still your property. That DNA, that's still my property. My DNA, that's still my property. You know, so like now they're saying your property right or your custody power was a property right that was tied to a so-called trust. All right. And like I said, and that was his responsibility as the guardians, because the father is still your guardian. Your father is supposed to be watch out for you, take care of you, etc. You know, and that's not something that we're trying to run away from. These are things we're trying to be able to strengthen by being able to have our rights enforced as fathers. Because children today don't have a foundation to stand off of. They're being raised by social media. They're being raised by what's entertaining. They're being raised by fast foods. They're being raised by sodas and sugars and all these jazz. They're being raised by mothers who are still immature in the mind. They're being raised by also even a lot of fathers who are still immature in the mind, things of that nature, because he don't know who he is. So as we all can see, because of if you don't trace the origins of these problems back to the foundation that they come from, we're going to continue to keep falling and having problems that cannot be band-aided. And the only way for you to fix this issue that's going to turn into, I was going to say, a worse pandemic than it is, you have to go back to the root. And in this case, we're going back to 1660. So Grossberg describes the notion that fatherhood is a trust as an American innovation. You hear this? Fatherhood is a trust as an American innovation, one that he enlists in support of his thesis as yet another example of the anti-patriarchal ethos embedded in Republican family law. So now think about it. And I'm not supportive of no republic. I'm more for the monarchy. You know, I don't need to. Too many people having power is still not good either, because they all have different minds and agendas, whatever. And I know republics will be back to the people. Well, the people is all sick in the mind and stuff like that. You want to be giving them any type of power? No. All right. So even when they're saying the republic family law is tied to the, it says it's tied to the anti-patriarchal ethos that's embedded into the to what many people today saying is what an American republic is supposed to be about. But as we can see, that if that was the case, then the fathers would have their rights. So if America right now was literally operating as a so-called republic, they would still be enforcing the so-called right to the father. If America itself was operating underneath the so-called patriarch, it would be enforcing the rights of the father. So for those of you who probably won't never hear this video, but those who do pay attention to it, you can't say that you're suffering from the patriarchy. You haven't been suffering from the patriarchy in almost 400 years. You're suffering from a corporatocracy mandated or handled through judges, who are being lobbied by these corporations. So that means the corporations is one who's running this joint, because if they can lobby and have these judges make legislation and stuff in their favor, and then guess what? And now your children are utilizing the products that's coming out of these corporations to fuel their reality. Then that means these are your parents. Those are your gods. Those are your guardians. So those are your ones who are setting your script and setting you up for you to continue to keep falling. It's the corporations. All right. So I don't want to go too far into that one. We'll talk about that in another video. Let's continue. So in addition to giving short shrift to the decisions of the English Court of Chancery, Grossberg and Mason further miss an opportunity to identify the true nature of English child custody law in their discussions of decisions made by English common law courts regarding child custody. The focus on English common law cases is an understandable one because the early American child custody cases, to the extent that they cited English precedents, cited those cases rather than the decisions of the Court of Chancery. But neither Grossberg nor Mason notes this fact. As a result, what emerges from their analysis is a skewed picture of English child custody law. When a suit regarding the custody of a child was brought at an English court of a common law, usually in the form of a habeas corpus petition asking for the delivery of the child, the court could only enforce, or in certain cases refuse to enforce, existing custody rights, but could not change them. When Grossberg and Mason discuss English common law cases, they failed to mention that the reason these cases refused to alter the right of custody was that to do so was the sole prerogative of the Court of Chancery. You hear this? You hear this? All right, so to alter any type of child custody rights, like they said, was the prerogative rights of the Court of Chancery. English Chancery. They're the ones who's supposed to be changing that joint, not so-called these Vice Admiral Maritime courts that you're dealing with today. The misleading nature of the account of English child custody law provided by Grossberg and Mason is exemplified by their treatment of the case of de Manville. The de Manville case was heard twice, first in the Court of King's Bench, a court of common law, as Rex vs. de Manville, then in the Court of Chancery as de Manville vs. de Manville. Both Grossberg and Mason discuss only the version of de Manville decided by the Court of King's Bench, Rex vs. de Manville, was initiated by a writ of habeas corpus filed by the mother asking for the delivery of her infant child from the hands of its father, who she claimed had taken the child from her by force. The court ordered the child delivered up for examination, determined that it was not in danger of any harm, and returned it to the father, on the basis that he, having the legal right to custody of his child and not having abused that right, is entitled to have it restored to him. You hear this? Brothers, pay attention. If you want your children, as you can see, I've writ of habeas corpus, produce the body. I need you to bring my child to court. I have rights. I'm a father. I'm an Englishman. And my rights goes all the way back right before you were created. Give me my child. Give me my property. This is what they don't want to hear. This is what they don't want to hear. But before you do this, make sure you have your house together. Like I said, get your house in order. Make sure you have the foundation. Make sure you're mentally prepared. Make sure you have the resources. Because the courts don't make this easy for you. Especially when you start standing on trying to enforce your paternal rights. And I'm not talking about from out of the sky and in areas that they can't recognize, but I'm talking about in law. So when you start utilizing the law and you utilize your status in law, then things change. But if you don't know who you are, last thing you need to do is go in there and start spewing out somebody else's law, someone else's legislation or statute that has nothing to do with you. All right, let's continue. Looked at in isolation, Rex de Manville indeed seems to demonstrate, as Mason puts it, the doctrine of a father's paramount right to his children. But had Mason and Grossberg examined the subsequent decision of de Manville versus de Manville, heard in Chancery, they would have found a very different interpretation of the basis for Rex versus de Manville's refusal to deny a father the custody of his child. The Court of Kings, once again, two different courts, as you can see, one who's underneath the king, parens, patriae, Rex, which is the king versus de Manville, and then the one had de Manville versus de Manville, but these are just like state cases. All right, so the Court of King's Bench, when the child was brought up by habeas corpus, declined to interfere. And I am not surprised at it, for that court has not within it by its constitution any of that species of delegated authority. that exists in the king as parens patriae and resides in this court as representing his majesty. The court of king's bench cannot alter a father's right of custody because the authority to do so was vested only in the court of chancery. So you hear this? So the king can do it. It was only chancery. As this note will discuss below, that Manville versus de Manville in fact expanded the discretionary power of the court of chancery to abrogate a father's right to the custody of his child. 2. Historians of parens patriae. Historians of parens patriae subsume the historical development of child custody law under a larger exploration of that doctrine. Neil Cogan, Lawrence Custer, and John Seymour have traced the development of parens patriae into a doctrine that justifies state interference between parent and child. In doing so, I'd like to see how they did this. They overemphasized the relevance of parens patriae in early child custody cases, concluding that child custody law originated with parens patriae. Although Cogan, Custer, and Seymour do mention the testamentary guardianships, they treat them as an incidental element of, rather than the driving force behind, the cases employing parens patriae. The modern version of parens patriae may have emerged into the context of English child custody law, but English child custody law did not grow out of parens patriae. To the contrary, the parens patriae doctrine was relevant to child custody primarily in that it gave the court of chancery jurisdiction to regulate testamentary guardianships. All right, so like they're saying, the father's rights came way before parens patriae. All right, it didn't come after so-called 1660 or whatever. So, like they said, so the contrary, the parens patriae doctrine was relevant to child custody primarily in that it gave the court of chancery jurisdiction to regulate testamentary guardianships. That was it. The history of parens patriae provided by Cogan, Custer, and Seymour traces its extension to justify the Court of Chancery's regulation of testamentary guardians in 3 early cases: Falkland v. Bertie in 1696, Eyre v. Shaftesbury in 1722, and Shaftesbury v. Shaftesbury in 1725. A careful reading of these cases reveals that while the courts were not as meticulous in separating their analysis of jurisdictional and substantive issues as courts today, the parens patriae doctrine was of the former type in the child custody context. The first case to mention parens patriae in conjunction with infants was Falkland. In response to the infant petitioner's argument that the court should overlook as overly harsh in a clause in her uncle's will conditioning her inheritance on marriage to a certain man. The Falkland court, though ruling against her, agreed with her proposition that the court of chancery could interfere on behalf of infants. In support of this proposition, it summoned up the doctrine of parens patriae, and in doing so described a doctrine that had never been described before. But only did Falkland rename parens patriae as patria. That means father of the parent or parent of the father. I don't know. But it also advanced the novel idea, father of the country. That's what I meant. But it also advanced the novel idea that the doctrine extended to infants, that the portion of parens patriae related to infants had formerly been exercised by the Court of Wards, and that upon the abolition of the Court of Wards in 1660, the jurisdiction over infants reverted to the Court of Chancery. All right, Falkland's statement on parens patriae was simply dictum. This dictum was subsequently, as Seymour described it, adopted as a correct statement of law by a petitioner in Eyre who relied upon the Court of Chancery's parens patriae jurisdiction over infants and asking it to intervene in the testamentary guardianship. When the case returned to the Court of Chancery 3 years later in Shaftesbury v. Shaftesbury, the court itself referred to parens patriae as justification for its authority over testamentary guardianships, thereby reaffirming the Court of Chancery's jurisdiction to care for the nation's infants in its role as parens patriae. As the historians of parens patriae demonstrate, in the years following Shaftesbury, the Court of Chancery continued to refer to its parens patriae power in cases involving the regulation of testamentary guardians, and again in cases extending this regulation to fathers. Give me 1 second. Okay. B. Earlier accounts. that the histories of English child custody law provided by 20th century scholars emphasize certain aspects of that history at the expense of others should perhaps not be surprising, because as the section will now show, remember, a lot of the stuff that they're doing, a lot of what they're doing is misappropriating the information to usurp the rights of the father to allow others to have control of the father's property, which is what? His children. So let's read what it says. So as this section will now show, similar distortions were present in earlier tellings of the same story, consistent with the American historian's belief that English child custody law afforded absolute paternal rights was a 19th century effort that mischaracterized that law in an effort to obtain rights for mothers. You hear that? So they mischaracterized the law in an effort to try to get rights for the mothers. But remember, they already controlled the womb via partu sequitur voluntatem. So it's like they're playing tricks. They're playing tricks with mothers, and like we said here in the West, they're playing tricks with matrix. They tricking the women, the mothers, and it's right here in their face, and no one is telling them, no one is speaking the truth to them. And I love my mothers and the sisters much, and that's the reason why I have to bring this truth to them, because a lot of what they're experiencing mentally and all that, it can all be traced back to the origins of the stemming of the foundation of the so-called country. All right. So, and consistent with the parens patriae scholars' emphasis on that doctrine was a debate in the late 18th century about the source of the Court of Chancery's jurisdiction over fathers. 1. Maternal rights advocacy and the myth of absolute paternal rights. The crystallization into accepted truth of Blackstone's notion that English fathers had absolute rights to the custody of their children began in 19th century England with the advent of agitation for maternal rights. As marital dissolution became increasingly common at the beginning of the 19th century, more and more cases emerged in which mothers competed with fathers for the custody of their children. Pause. So as you can see, after the breaking down of, let's go start the anti-disestablishmentarianism, which was the disestablishment of the Church of England, or the church state, or the state church. My bad. Disestablishmentarianism was the disestablishment of the state church, and this time before the creation of the several states, the United States, it was the Church of England. Now, as we can see, because of this Blackstone speaking, is clearly still underneath that time. There wasn't no having divorces and stuff like that. Like, these things, of course they happen, but they weren't as common as folks think they were. Especially like today, people are getting divorced through every 24, 48 hours, it seems like. And then you're dealing with what? Child custody battles. Now you're dealing with that, fighting these issues back and forth. So these were stuff that was trying to be curved a long time ago. Some shape, fashion, or form, something happened to start bringing a rift between man and woman. These are the things we have to talk about, because for life to continue to go on, we have to become a more perfect union once again. And the only way for us to be able to do so is by explaining what got us in the mess to begin with. Give me 1 second. Apologize. All right. We got to go back to knowing what it is that brought us back together. What brought us together the first time. And this is why we say it's very important for you to know who you are via genealogy, via customs, cultures, traditions, and things of that nature, because it's about the house. And the house ties to the kingdom or the nation, and how the household or our personal household operate is going to dictate what gets put out there into the society and the community at large. So if we're having problems within our own personal households, there's no way that we can be as productive and inspiring for the society and the nation as a whole as we would like to be, because these aren't things that we want to be recognized as normalcy. Divorces shouldn't be normal. I understand it happens. I understand people aren't, going to always get together and last. Things change, but they shouldn't change if the foundation is solid, if what you started off from is the same, because nothing is new under the sun. They keep telling us that we keep hearing this motif over and over again, that there's nothing new under the sun. So if that's the case, then we need to be able to try to maintain what we have as long as possible, with peace as long as possible. And what we're trying to maintain is abundance, our posterity. We're trying to maintain having freedom to the land, clean air, food, water, the things that allows us to be able to do good deeds and random acts of kindness, to be able to look and care about our fellow man as equal and not seeing them less than. These are all things that we have to bring back to our psyche that has, unfortunately, because of the corporatocracy that you're living in, are brainwashing you. They're brainwashing you, brothers and sisters, to become something that you're not. And you can tell that they're brainwashing you to become something you're not because your DNA is changing over, and DNA changes show via outside effect. So look, a lot of people who don't understand traditional values and things of that nature, and look how they physically are transforming. They are losing the structure that they come from, aka their identity from their genealogy. So they no longer who they think, they no longer who they supposed to be by blood. They are now something created by corporations. All right? Because by blood is by God. But these corporations are not of God. They are of man's mind. And sometimes, as we can see, man's mind, and when I mean man, I mean human. Human's mind is not always what it's cracked up to be when it comes down to what you and I may need. Let's continue. So the view that fathers had absolute rights to the custody of their children grew out of these cases. First, in the jurisprudence itself, which repeatedly rejected maternal rights as a sufficient basis for the removal of children from their fathers, and second, in the treatment of these cases in the influential writings of Caroline Norton, whose crusade for the creation of maternal custody rights resulted in the passage of the 1839 Custody of Infants Act. All right, so as you can see, that a lot of the issues, them misappropriating the father's rights and all this to usurp, to remove the father altogether, this was an agenda. This was a thought out agenda, and we can see purposely done. So therefore, there is no structure. Once the structure is gone, there is no you. Once the foundation is gone, you're just floating, and you're just waiting to fall down. All right. So at this moment, that's the reason why a lot of households are failing, because the structure was supposed to be there. Households need a mother and father, not just a mother and not just a father. It needs both. Children need both. And this co-parenting stuff out here, as we can see, is a lie. It don't work. It's harder than many people think it is because it creates confusion. So as you can see, these people have manipulated us to fight each other. They're manipulating you and having you out here creating random babies with people who y'all don't even have the same foundation. Y'all don't even know where you're going. You don't even believe in the same stuff. It's confusion. That y'all getting together and breaking up, and I'm definitely to blame for this. I've done it myself. That's the reason why I'm talking about it. And I'm suffering the consequences of my actions. And it's not comfortable. No part of this is comfortable, but it has to be said because something has to be done. And as we can see, they have been placating for a very long time by playing tricks on my matrix to get her to help them foil the father, so that way the father don't have any custodial rights. Why? Because the way that the father sets the children will help set the society. And think about it. A lot of fathers will not allow what these corporations are doing to their children when the mothers are, running the households. That shit won't be out. It won't be playing. It will literally be eradicated. This is the reason why they had to get the fathers out of the picture. For the corporations can continue to keep doing what they're doing. That evil agenda that they're pushing going across the country, across the world, like I said, the four corners of the world, they had to utilize one of the most precious things that a man will want to have in his life, and that was his woman, his wife. Use her to usurp one of the most precious things that a father will have, which is his children, his posterity, and now have them being raised by the same evil that our predecessors were fighting against. Think about it. That's what's going on. How you think the devil was going to get his warriors? He had to have someone create them. Let's continue. So as, where did I leave at? All right, so A, so the lack of maternal rights before 1839. Now remember, we already told you what happened from that. That was because of Part 2 Sequitur Verentorium. Prior to 1804, the Court of Chancery regularly granted mothers requests to restrain fathers from interfering with the custody of their children. The basis of these decisions was never that the mother had a right to the custody of her child, superseding the right of the father, but rather that the father had lost his own rights to custody. So they said the mother was going for custody for the children because the father lost rights to the children. And that makes sense, especially if they're playing these tricks on both of us. But if the mother, as long as the mother is recognizing the father still as who he is and trying to maintain the sanctity and continuity of what we were as a unit, a union for the kingdom, to make sure that we keep society moving forward in a productive, positive way underneath God's covenant. That makes sense. That the mother will go for custody if the father lost his rights. But we know why the father was losing their rights. It's because the judges were usurping them. All right? So in the Manville versus the Manville case of 1804 and in cases that followed, mothers who sought the custody of their children began to argue for this custody on the novel basis that maternal rights superseded paternal rights. You hear this? So they say maternal rights superseded paternal rights. This is her basis or their basis in 1804. And it was when custody became an issue of competing maternal and paternal rights that judges ruled in favor of fathers, holding that paternal custody rights are superior to maternal ones. But they never denied the superiority of judicial power to that of fathers. You hear that? They never denied the superiority of judicial power to that of fathers. So they're telling us that the courts had so-called superior power than the fathers did, when we know that was not the case prior to 1660. The absence of maternal custody rights was famously articulated by Blackstone in 1765. A mother, as such, is entitled to no power, but only to reverence and respect. Even in Blackstone's time, however, the weakness of maternal rights was less extreme than his famous quote implies. Most legal scholars of the 17th, 18th, and 19th centuries, Blackstone included, agreed that the mother had the right to her child when no other guardian existed to supersede her. It was only relative to other guardians, including the father and the father's appointed guardian, that the mother had no enforceable custody rights. You hear that? So if the father was there, or if there was an appointed guardian, and remember these appointed guardians are by judges, then the mother had no right to enforce her custody rights. But as we can see, all of that changed. Once they got the father out the picture and they see that they can make money off the mother still, by making her think she have the rights, but actually they're telling you this, but the best for the child, because guess what? They can go and take the child from the mother as well. And they do all the time. All the time. So in the Manville, a mother petitioning for the custody of her infant daughter advanced the argument that children of such a tender age cannot without great danger be separated from the mother. The Lord Chancellor, hearing the Manville, refused even to consider the theory that children belong with their mothers. I do not mean to decide whether I am at liberty to pay attention to the affidavit of the wife, preferring instead to proceed as if the mother's argument did not exist. The court will do what is for the benefit of the infant without regard to the prayer. As this note will discuss below, the Manville, in fact, reaffirmed and extended the power of the Court of Chancery to interfere with fathers' custody over their children and even to remove children from their fathers altogether. Once again, this is the court usurping the father's rights. At the same time, however, de Manville emphasized that in deciding whether to abrogate paternal custody rights, the court did not need to consult the mother's rights or desires, but only its own discretion. In this instance, the court's discretion led to order, on the one hand, that the father be restrained from removing the child out of England, and on the other hand, that the child not be delivered to the custody of the mother, since the mother had separated from her husband without obtaining a legal separation or a divorce, and to place the child with her will be to condone this illegal arrangement. As mothers in subsequent years made claims to their children on the basis of custody rights, the Court of Chancery held repeatedly that mothers have no right of custody against fathers, although in each of these cases the father had behaved in a manner that might in itself justify removal of his children: adultery, irreligion, cruelty. The mothers lost when they attempted to detain the children on the ground that they had a right to do so. In Ball, the court even refused to order that a father allow his wife access to her children, holding that the court did not have the power to interfere in a father's rights unless the father himself lost these rights by his own misbehavior. In 1836, Rex v. Greenhill articulated the reasoning behind this repeated rejection of mothers' claims to custody rights. Any doubts left on the minds of the public as the right to claim the custody of children might lead to a dreadful disputes. Although willing to remove children from fathers, the courts were reluctant to do so, where this might encourage mothers to think that they had a right to their children's custody. Where a claim to custody was cast as a dispute between mother and father, the rule was clear. The father's rights dominated, but the judicial process stood above both. And I'm going to stop there and going to talk. Let me see. All right, so I'm just going to do a little quick summary from that, because many brothers and sisters don't understand how that ties into Malachi 4:6. And Malachi 4:6 was known as the last command in the Old Testament. So let's go ahead and talk about that. The origins of, once again, the legal shift of that in England. And like they said, between 1660 and the early Victorian era. Give me 1 second, pull this on over. Okay, so the legal shift of England, 1660 and 1839. Between the restoration of 1660 and the early Victorian era, 1839, English child law underwent a profound transformation, which we were speaking about. Pre-1660, English common law treated children as legally under the absolute authority of the father, patria potestas, rooted in Roman law and feudal custom. Courts rarely intervened in family matters. The household was considered a private jurisdiction governed by paternal authority under God. You hear this? So if the household is not governed under God, you don't have no rights. The father loses his rights to his children. So as you can see, the father's position and what he does and stand for is just as important as the mother, because if he is not an upright man and standing according to the principles and the value system of the English in regards to us being godly people, he lost his rights to the children too. And that's what we can see what's going on today. As long as they keep the fathers from being godly, they can make sure that they can usurp all your rights in the courts. Y'all see, brothers, I'm trying to give y'all a game. This is how you wake up, and you have to be, and I'm speaking to English. I'm not talking about any other so-called nationality. I'm talking for those of you who have English genealogy, who have been placating to be considered quote-unquote Americans underneath those so-called racial classifications, white, black, colored, whatever you want to identify as. It's time for you to wake up. It's time for y'all to grow up. This is what that's going to do. This is going to force you to have to grow up. All right. So it says, however, by the late 17th and 18th centuries, chancery courts began asserting jurisdiction over children, not as property, but as wards of the crown underneath the doctrine of parens, patriae, parent of the nation. This was revolutionary because once this brought the rise to judicial guardianship. Like we spoke about, key developments included: one, the court of chancery intervention where fathers were abusive, negligent, immoral, or financially irresponsible. So this is, as you can see, this is what happened, fellas. This is what you need to do. Get your house in order. Get yourself in order. The rise of equitable principles, prioritizing the child's welfare over absolute paternal rights. So it is still about what's best interest for your child. But as father being there, it's still a best interest of a child. It just requires a moral father. Judges increasingly acting as moral arbiters of the family, not merely legal referees. By the early 1800s, English court had effectively redefined the family as a unit accountable to the state, not solely to God or lineage. So you can see right here, they separated the family outside of God and put you underneath the state. Put you underneath the state. 3. The Custody of Infants Act of 1839. This decisive break came with the Custody of Infants Act of 1839. For the first time, mothers were granted legal standing to petition for custody. So in 1839, that's what started for mothers to be able to start getting the rights to children. Courts were empowered to decide custody based on moral fitness, not blood right. All right, so it was you morally sound to be raising your children, all right, or the child. Judicial authority formally replaced paternal headship in custody disputes. So no more father having a head consideration. It's now the judges, the court, and them are making the decisions. And the worst part about it now is because these courts are American courts. They're not English courts. They're American courts. And American courts, as we see, are pretty much being lobbied by corporations. So these courts are all ran by our corporatized courts. So like I'm saying, you're not living in a patriarchy. You don't even live in a matriarchy. You live in a corporatocracy. All right? This marked the end of the ancient English household model, where fathers were stewards under God, and the beginning of state-mediated family governance. Do you hear this, brothers and sisters? Do you hear this? Now, you got to remember, in 1839, in America, you was, not all of us, now I have to explain that, because not all people so-called of color during this time were so-called slaves. There were free people of color before slavery, and there was free people of color after slavery. And that's what I'm trying to explain to many of you who are out here teaching, who think everybody during this time was slaves. No, they were not. No, they were not. And that's why I'm saying even the 14th Amendment don't apply to all of you or many of us. I don't condone the 14th Amendment because it doesn't apply to me. Why? Because my predecessors weren't slaves. So I don't even talk about that. All right. So let's go ahead and go further. Malachi 4:6, the prophetic counterpoint. And he shall turn the heart of the fathers to the children, and the heart of the children to their fathers, lest I come and smite the earth with a curse. So what's going on here in the West? The land is cursed, brothers and sisters. Many of you don't even own land. Many of you don't even know how to grow food. Many of you, your whole life have been predicated paying rent. You have no foundation. You don't know where you come from. You don't know your genealogy. You don't know history. You don't have a moral compass. Look at what's going on and been plastered on social media. Look at how your sons are acting. Look how your daughters are acting. The land is cursed, brothers and sisters. But y'all don't believe in prophecy. Y'all don't believe in what they were writing in these books. Why do you think these people were writing this stuff in these books? so that way you don't forget. But unfortunately, that seems to be a common problem with us, that we like to forget. Why? Because forgetting is comfortable. Y'all don't want to deal with the pain, but guess what? You're going to have to accept it. You're going to have to accept that your predecessors were good and bad. You're all not innocent. I don't care what you claim and identify as. You're all suspect of doing ill. Look what you're doing to each other now. Debating back and forth about what and getting where? Nowhere. Fast. Because y'all moral compass is off. Y'all don't care about each other. And it shows. Let's continue. So in the biblical context, Malachi 4:6 speaks directly to covenantal order, not sentimentality. So once again, this is a covenant. And the English people know you're under a covenant. Y'all broke the covenant. And that's why you're suffering as chattel property here underneath amnesic or mental illness, lunacy. All right? The turning points of the biblical context, so the turning of hearts is relational restoration, all right, not legal enforcement. It assumes fathers already possess authority but have abandoned responsibility, which is true. A lot of you men have abandoned your responsibility as fathers. Step back up. Get your house in order. Get yourself in order. Reach out to other men to help shape and mold you to be a better man, so that way you can be a better father, so therefore your heirs, your posterity, can be good people to do good deeds and random acts of kindness, all right, and which would set them back underneath the covenant. And judgment comes when mediation replaces reconciliation, all right. So this is important. We have to reconcile. We have to reconcile. In other words, God restores families from the inside out. Courts restore them from the outside in. So it's not even about the courts setting you back in line. You must do this internally. And then it's an inside out thing. Once you set yourself up internally, your whole life will start getting in proper alignment. You'll know what to say. You'll know what to do. You won't be acting certain ways. You won't be talking to certain people. You'll just know. And it will come to you in a flash, but things will just start making sense. All right, 5. In law versus prophecy, the core tension. So English legal evolution, Malachi 4:6. Judges replace fathers, Malachi 4:6. Fathers are restored. Authority is transferred, Malachi 4:6. Authority is reconciled. So as you can see, what I'm showing you, what happened. The courts them usurp God's law. They usurp God's commandments and order and all that. And so I'm reading so you can see. And I'm glad to have the assistant ChatGPT help me break this down for you so that way you can understand. The children become wards of the state. That's underneath parens, patriae, and America. But parens, patriae in England, children are wards of the crown. Malachi 4:6, the children remain heirs of lineage. So that's what we're looking for. That's what we want. I want my children to follow me, my footsteps, because my footsteps are underneath a divine covenant. And I want them to be underneath that divine covenant. But if the mothers aren't operating underneath that covenant, and if the mothers' households aren't set in that covenant, then I can't foresee my children following my footsteps to be back underneath the divine order. This is once again why I did the video about the Canaanites and the sons of Isaac. Because the Canaanites, the merchants, the traders, today is who we would call the Americans. The Americans are the Canaanites today. The sons of Isaac, or we call it the angelic sons of Isaac, are us Anglo-Saxon Berbers. I'm not talking about the WASP. I'm somebody completely different. Us Anglo-Saxon Berbers. Because the WASP operates still under the Canaanite identity. They still operate as Americans, which I'm telling you are Canaanites, merchants. traitors. All right. And then it says, law intervenes due to collapse. Repentance prevents collapse. So to bring the order to keep us from falling down is when the fathers and the children come back. The children are back underneath the father. The father heart is back with his children to help keep collapse from happening. Because as we see what's going on here in the West, you ain't got that much time. Judicial intervention in custody law arose because fathers in the households failed, not because courts were meant to replace them permanently. And Malachi warns that when this turning does not occur, the result is societal curse, fragmentation, and generational rupture. Generational rupture and legal overreach. So once again, brothers and sisters, it has been an honor to come and bring this information to you. I know it's not easy to swallow because it's not easy for me to have to put this stuff up together and talk about it. But we are living in the day and age that, as they showed you, no one is talking about it because no one cares about the Father. No one has been caring about the Father for quite some time. And when you don't care about the Father, you innately not caring about the children. And when you're not caring about the children, you definitely ain't caring about God. So as we can see that we all have been fallen. And we have been falling for a very, very long time. And if we don't do what is required by stepping away from this atrocious reality that this corporation, this corporatocracy is enforcing on you, you potentially are going to be suffering the same ill fate that our predecessors did when they were trying to prevent the Vikings from taking over England. And with that being said, brothers and sisters, I love you. Stay tuned for the next video. Please like, share, subscribe. I love you. Take care of yourself. I'm out.